Okay, good. Let's get into this real quick. Very good. Here we go. All right, so here's what you need to know. Basically, under the Social Security Special Agent Handbook, there is a section that specifically talks about it's Exhibit 1-2, subsection X, relationships with the news media and how they share information with basically the general population. The Department of Justice has issued guidelines that prescribe policy instructions concerning the release of information by Department of Justice employees relating to criminal and civil proceedings. See 28 CFR 50.2. Office of the Inspector General personnel must familiarize themselves with and follow these guidelines. In addition, in the course of joint investigations between an Office of Inspector General and the Federal Bureau of Investigation, wherever a news release would be permitted pursuant to the guidelines noted above, the Office of Inspector General must coordinate the release with the Federal Bureau of Investigation and the Department of Justice. Now, I pulled that specific law. What's important about this video is that it will teach you when they are allowed to release information. Sometimes they're required to actually check with the FBI first as to whether or not they can release investigation information about what's been going on. Let's get into it. This is 28 CFR, section 50.2. 50.2, release of information by personnel of the Department of Justice relating to criminal and civil proceedings. The SSA has to follow this rule, just like the Department of Justice. The availability to news media of information in criminal and civil cases is a matter which has become increasingly a subject of concern in the administration of justice. The purpose of this statement is to formulate specific guidelines for the release of such information by personnel of the Department of Justice. So in other words, to summarize, they are saying with the government that the government feels like because of the news stories that are getting out, that they're not getting a fair shake. So to combat that, they're looking at when it is okay for them to release information that would give the government a fair shake. But they're also required sometimes to not release information, which puts the government in a position where it doesn't look so good. So that's something to consider here. Section 2. While the release of information for the purpose of influencing a trial is, of course, always improper, there are valid reasons for making available to the public information about the administration of the law. The task of striking a fair balance between the protection of individuals accused of crime or involved in civil proceedings with the government and public understandings of the problems of controlling crime and administering government depends largely on the exercise of sound judgment by those responsible for administering the law and by representatives of the press and other media. So in other words, the government is saying, in order for us to get a fair shake, to release information that will basically create a fair backdrop for a claim, a situation, somebody getting prosecuted, somebody who's been investigated, and then the news of that investigation being released to the general public. They're saying that they have to be careful with what they release. They have to hide stuff sometimes, and sometimes they're not allowed to release stuff in general. Section 3. Inasmuch as the Department of Justice has generally fulfilled its responsibilities with awareness and understanding of the competing needs in this area, this statement, to a considerable extent, reflects and formalizes the standards to which representatives of the department have adhered in the past. Nonetheless, it will be helpful in ensuring the uniformity of practice to set forth the following guidelines for all personnel of the Department of Justice. Section 4. Because of the difficulty and importance, okay, so basically that last paragraph, the whole idea there was they are basically summarizing down what they normally do. They want people to keep a continuous, formal, structured approach to this. They want everybody to follow the same approach. Because of the difficulty and importance of the questions they raise, it is felt that some portions of the matters covered by this statement, such as the authorization to make available federal conviction records and the description of items seized at the time of the arrest, should be subject to the continuing review and consideration by the department on the basis of experience and suggestions from those within and outside the department. So in other words, when they come and arrest you for, claiming that you were disabled and you're not, maybe you're working a side job and you didn't tell them, whatever, they're allowed to release certain information based off of the experience and suggestions from those within and outside the department as potentially a trial is going on. And then, a lot of times they'll do it afterwards to kind of summarize their position. Or frankly, what the government does now is they basically send out a press release, parading how successful they've been at finding the crime and then promoting that so that people are aware that they've been doing these deeds. Here are the guidelines. B, guidelines to criminal actions. Number 1, these guidelines shall apply to the release of information to news media from the time a person is the subject of a criminal investigation until any proceeding resulting from such an investigation has been terminated by trial or otherwise. So basically, they're saying use these guidelines throughout the entire process, before, middle, after. Number 2, at no time shall personnel of the Department of Justice furnish any statement or information for the purpose of influencing the outcome of a defendant's trial, which we all know hasn't been followed exactly perfectly. We've all seen that problem happen. Nor shall personnel of the department furnish any statement or information which could reasonably be expected to be disseminated by means of public communication if such a statement or information may reasonably be expected to influence the outcome of a pending or future trial. Which, to be fair, if you release any information or any facts about what was going on, it's almost always going to create some sort of change in the environment. That's why they'll order jurors to not watch the news, which is like, obviously lots of them watch the news. You know what I mean? They just don't tell anybody. So, whatever you release, you're going to affect the outcome of trial. That's just the way it is. There's no way around that. No matter what you do, it will affect the outcome. 3, personnel of the Department of Justice and also the SSA are subject to specific limitations imposed by law or court rule or order may make public the following information. Number 1, the defendant's name, age, residence, employment, marital status, and similar background information. Number 2, the substance or text of the charge, such as a complaint, indictment, or information. Number 3, the identity of the investigation or arresting agency and the length or scope of an investigation. Number 4, the circumstances immediately surrounding an arrest, including the time and place of arrest, resistance, pursuit, possession, and use of weapons, and a description of physical items seized at the time of the arrest. So like most facts of the case, they are allowed to put out there into the news about how they might arrest a retired person who is not paying taxes and doing some criminal activity on the side, or maybe it's a disabled person who was, basically doing things to get multiple benefits, setting up multiple social security. Could even be an SSA employee who's selling social security numbers. Could even be that. But basically, they're allowed to release most of the information as to what's going on if they want to. And when they do that, of course, it's not supposed to be to change the outcome of a potential trial. But look, let me read it to you this way. Let me rephrase it so you can consider this for a moment, okay? Add to the beginning of this sentence, will the outcome of a trial be changed if the circumstances immediately surrounding an arrest, including the time and place of arrest, resistance, pursuit of possession, and use of weapons, and a description of physical items seized at the time of the arrest, can be released to the news by the government? Will that information likely affect the outcome of a trial? And when you phrase it as like, if you do all these things, will that likely affect the outcome of a trial? The very simple and direct answer is, of course they will. But the government views this as a way to, let people know what's going on, give the government a fair shake as to what they're doing. But also at the same time, it places the government in an opportunistic stance to kind of advertise a bit as to what they've accomplished. Disclosures should include only incontrovertible factual matters and should not include subjective observations. In addition, where background information or information relating to the circumstances of an arrest or investigation would be highly prejudicial, or where the release thereof would serve no law enforcement function, such information should not be made public. There's a lot of gray room in that, but basically they're going to release what they want to release when they want to release it. You can always fall back on this at some point and say, well, that really prejudiced that case. That really created a prejudice against that person. That really created a bias against that particular person. But then it's too late. You know what I mean? Like, what are you going to do? A new trial? You know what I mean? It's too late at this point. Section 4, personnel of the department shall not disseminate any information concerning a defendant's prior criminal record. 5, because of the particular danger of prejudice resulting from statements in the period approaching and during trial, they ought strenuously to be avoided during that period. Any such statement or release shall be made only on the infrequent occasion when circumstances absolutely demand a disclosure of information, and shall include only information which is clearly not prejudicial. I mean, I don't know about you guys, but like, when does the government really need to release what happened during a criminal situation to the public, to the news? Like, when do they absolutely need to do it so that you know what's going on and you're satisfied? And some of you will say they need to release all the information because you deserve to know the objective and the subjective. And this is the middle ground. They get to decide at the government what they want to release, what they want to tell you, when they want to tell you. You know, they should again, notice the wording, because of the particular danger of prejudice, right? They ought to strenuously to be avoided during that period, you know, giving information. Any such statement or release shall be made only on the infrequent occasion when circumstances absolutely demand a disclosure of information. But again, they get to choose who, what, when, and where. It's up to them. 6, the release of certain types of information generally tends to create dangers of prejudice without serving a significant law enforcement function. Therefore, personnel of the department should refrain from making available the following. 1, observations about a defendant's character. Statements, admissions, confessions, or alibis attributable to a defendant, or the refusal or failure of the accused to make a statement. Reference to investigative procedures such as fingerprints, polygraph examinations, ballistic tests, or laboratory tests, or to the refusal by the defendant to submit to such tests or examinations. Statements concerning the identity, testimony, or credibility of prospective witnesses. Statements concerning evidence or arguments in the case whether or not it is anticipated that such evidence or argument will be used at trial. Any opinion as to the accused's guilt or the possibility of a plea or guilty to the offense charged, or the possibility of a plea to a lesser offense. Again, the SSA, along with the Department of Justice, along with the FBI, they get to release the information when they want to, you know. And this reminds me of kind of like Florida. Like you have sheriffs in Florida that release all kinds of information, you know what I mean, while they're wearing like the original, what they call the drip, the necklace of like the dealers, and you know, all that stuff. And to my degree, it's the opportunity for law enforcement to advertise the good that they're doing, because inherently law enforcement gets a bad rap if they don't get a chance to defend themselves. That's just the way it is. 7, personnel of the Department of Justice should take no action to encourage or assist news media in photographing or televising a defendant or accused person being held or transported in federal custody. Departmental representatives should not make available photographs of the defendant unless the law enforcement function is served thereby. This statement of policy is not intended to restrict the release of information concerning a defendant who is a fugitive from justice. So if you're a fugitive from justice, they're going to splatter that all over the place. They want to know, do you know where this person is? Since the purpose of this statement is to set forth generally applicable guidelines, there will of course be situations in which it will limit the release of information which would not be prejudicial under the particular circumstances. If a representative of the department believes that, in the interest of the fair administration of justice and the law enforcement process, information beyond these guidelines should be released, in a particular case, he shall request the permission of the Attorney General or the Deputy Attorney General to do so. C. Guidelines to civil actions. Personnel of the Department of Justice associated with the civil action shall not, during its investigation or litigation, make or participate in making. Wait a minute. I went the wrong way. Extrajudicial statement other than a quotation from or reference to public records, which a reasonable person would expect to be disseminated by means of public communication if there is a reasonable likelihood that such dissemination will interfere with a fair trial, and which relates to the following. So in other words, when can you like release quotes? Okay, So, with a fair trial, and which relates to 1, evidence regarding the occurrence or transaction involved, the character, credibility, or criminal record of a party, witness, or prospective witness, the performance or result of any examination or test, the refusal or failure of a party to submit to such, an opinion as to the merits of the claims or defenses of a party, except as required by law or administrative rule, and 5, any other matter reasonably likely to interfere with a fair trial of the action. Now, I want to know what your thoughts are when it comes to essentially how fair is it that the government gets to choose what information they want to release when they want to release it? Because to me, you know what I mean? Look, you know what this is. These are the pool rules for basically the federal government to advertise that they've found a criminal doing criminal activities. My point to you is, what do you think is fair? What do you think is not fair? Should we, the citizens, have more control over the release of information that we request? All right, short video, Attorney Walter Hnot. Please remember to like and subscribe. Head over to Google, type in Disability Resolution Law Firm, throw some stars up there if you like. I go live on Mondays and Thursdays to answer questions for free. And if you want a private consultation, mini contract is below. I'll catch you a little bit later. You have a wonderful day, and we will rock and roll from there. Attorney Walter Hnot, thank you so much. Bye-bye, everybody. Bye-bye.